Hello and welcome back to this channel. Happy Tuesday. I hope y'all are having a great day. I am having a super great day, but I am a little bit still under the weather. Okay, but I'm here, I'm managing, I'm trying to figure it out. Today I bought some drugs already. I got me some Tylenol, daytime, nighttime. Yes, Tylenol, acetaminophen. Okay, and then also I'm allergic to a lot of like the syrups and stuff, like other products, but I tried Buckley's for the first time. It's disgusting, but I hope it works and this can all clear up. But anyway, you're not here to hear about me being under the weather, okay? We're here to get into it. And today we're going to talk about a smear campaign that has been going on against the Wayfarer Party since the beginning, but it is in full swing right now, okay? It's still happening. So we're going to talk about the headlines, yes, that involve Justin Baldoni and Taylor Swift. Please. We're going to talk about Ruby Rose's current crash out and her attack on Bryan Freedman, and then we are going to get into the new filings, the motions in opposition for Blake Lively requesting treble damages and attorney fees. Wayfarers come back and it is spicy. Okay, so if you're ready, I'm ready. Grab your emotional support lip gloss. I know for sure I'm going to need it to get through this. You are in frame with Mandy Magnan. Okay, y'all, so today I am trying for the first time. This is called Champagne Toast. My housemate got it for me for my birthday, so I haven't tried it yet. I just opened it up. Oh my gosh. It smells like heaven. It smells like cotton candy. Oh, that's very sweet. That is a really good gloss. So this is from Bath and Body Works. It's called Champagne Toast. Let's see if it stays on. I definitely for sure like the gloss of it. And it's really smooth and it smells yummy. And also, don't get confused. I know I'm wearing a New York shirt, so everyone might think I'm in New York by Blake Lively's logic, but not true. I'm still in Toronto. I'm just wearing a New York shirt. So I just wanted to clarify that before we get into it, okay? And now I know it's not Friday, it's Tuesday, and on Fridays I go through a lot of your comments from the week, but I thought this one was bang on. Okay, so let's talk about this comment from Didimwazi8461. Thank you so much. Someone posted that Justin Baldoni's studio had a movie out about a man in his 50s who went back to college. They do. It's called A Senior. It's only in select theaters, and I think I might be going to see it tonight or definitely this week, but it is only in select theaters. It's called The Senior. They go on to say, so they said it was Blake Lively trying to hijack the headlines as she has words like studio and university, college in her post. Even when Scarlett had her movie out, she posted something that was like that in the headlines. Also, it could be because she had a loss in court, so it may have been to cover that. And this was and is so true. Whenever it seems like Blake Lively is having a little bit of crash out on IG, it's usually always a distraction from what is actually happening in the courts. And I find it very interesting that on the same day that the Wayfarer parties respond to Blake Lively's little request for treble damages and attorney fees, that we get all of the headlines about Taylor Swift. Oh, this is the biggest load of BS that I've ever seen. When you now Google Justin Baldoni, what comes up? All of these headlines about Taylor Swift and a man trying to serve papers to Taylor Swift at Travis Kelce's home. Every single one of these media outlets should be ashamed because what they've reported is lies. This all came from Star. Star reported on this, and they're all pulling it from Star. I guess they got an exclusive. Allegedly, it happened on September 16th at 2 a.m., where a man hopped over Travis Kelce's fence and was arrested for trespassing, and he said he was trying to serve papers for Justin Baldoni. Why that story doesn't make sense and why it's BS, first of all, On the arrest, it doesn't say anything about being a server or a PI or anything, but also Venable, Taylor Swift's law firm, has been cooperating this whole time with the courts and with Wayfarer, as well as he wouldn't be serving papers on behalf of Justin Baldoni. It would be the Wayfarer parties. And if a PI is hired, it's usually through other parties. So the whole story just doesn't make sense. It's a big kerfuffle. I think it's absolutely BS. And Mackenzie, the girl with the sparkled blue spatula, did some great work. And this is what she had to say about the deep dive that she did about the reporter who actually came up with this story.
Whether or not this is actually the journalist that made the comments or the one that Bryan actually spoke to, by no means confirmed, but I thought it was odd that out of all people, it would be tagging him in this. So I wasn't able to find too much on Doug, so I started digging further into any of the other authors from the Star that covered the deposition with Taylor Swift. And I found Olivia. She's written many favorable articles about Blake, Taylor, and Ryan, and she just so happens to be an aspiring actress. When I looked into some of the acting training that she's done so far, I found some clues that may, lead somewhere. It might be a coincidence. It might not be, but something worth to mention. So let's talk about Anthony. He's worked for Marvel and DC. Who else worked for Marvel? Oh, Ryan. He's also featured in Law & Order multiple times. And when I went to his Instagram, he's following Ryan. Anthony did congratulate Olivia on getting signed to an agency. When I looked further into Tom Buck, he also has been featured on Law & Order multiple times. Now here's why that's important. Who do we know that's a huge fan of Olivia Benson from Law & Order? Taylor Swift.
Again, let's not believe everything that we read. We really have to take some critical thinking here and figure out why this is being said, where it's coming from, who's saying it, and the timing of it, okay? There is no actual evidence, and I'm really tired of just getting all of this information just for headlines, clickbait, rage bait, and it's just absolutely preposterous at this point. This was clearly for PR and PR only. And until we hear otherwise from anyone else, or there's actual evidence that this occurred, I will not be believing it. It doesn't make sense that Venable, Taylor Swift's lawyers, would not accept service on her behalf. She already has many stalkers out there. I believe this was probably just another stalker, honestly, in my opinion, until we get any more information. But it's crazy that all of these media outlets are running with the exact same story, that a process server for Justin Baldoni broke into Travis Kelce's house to serve Taylor Swift at 2 a.m. It doesn't make sense, okay? And the PIs and the servers and all that, they still have to follow the law. They're not allowed to just do criminal activity. It just, the whole thing doesn't make sense. And knowing that she already has stalkers and all of this stuff, it would not make any sense for her lawyers to not accept service on her behalf if they were trying to serve her a subpoena. This is just all for a distraction, which Blake and Ryan are really good at doing. It further smears Justin Baldoni to make him look like a sociopath and desperate for Swiftie and Taylor Swift. Let me tell you, they are not going to do anything that is going to harm their relationship, whatever it is, with Taylor Swift. And they're not going to do anything to have the Swifties at them. I mean, everyone plays on really delicate ground when it comes to Taylor Swift. And also all those media outlets literally are saying denied Wayfarer. This comes after the judge denied Taylor Swift being deposed, which is it's beyond misleading. It's a lie. The judge never denied Taylor Swift being deposed. He denied the extension to the end of October for her to be deposed. These kind of things and these kind of lies and this kind of misinformation is really, really a huge problem right now in the world, because people are only reading the headlines. They're not doing their own work. They're not, involved in the case, and they're going to start to believe that. And this is just one step further, I think, to taint the jury pool against Justin Baldoni and also the world against him, because everything that they've done so far hasn't worked. And it's beyond cray cray. It's just, Yet again, more smearing from the other side, creating these stories without any proof. And the smearing continues because now we have another actress, Ruby Rose, who is on crushing out hard over Bryan Freedman. And we're going to get into why she does not like Bryan Freedman. It seems her and Blake have a little bit more in common than the world knows about. But it all started here on Threads when Ruby Rose came out and just said like the craziest lie. She's following the exact same thing that the media headlines did without doing her own research and homework and knowing anything about the case. She wrote, the Baldoni legal team, Bryan Freedman, who is one of at least 6 lawyers against me in Warner Brothers situation, I think that is, sent a private investigator, Bryan's favorite tool to scare people, to break into Travis Kelce's property at 2 a.m. and give her a deposition document, despite the court's recently shutting the request down. He needs to be investigated for his antics. Frightening. Now, the amount of people that liked and commented on this without doing their own homework freaks me out, okay? And a lot of people are like, oh my God, that's such an abuse of power. Da, 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 da. And then we get to hear where she's like, I didn't want to post this link because it's TMZ. It continues, okay? But look at all the people's commenting, like really buying into what she's saying here. I have no idea what that picture's about, nor do I care. And then we go here where it's Ruby Rose. She's talking about Disney, saying, I wonder if Jimmy has to go back because he clicked past the terms on his Disney Plus contract. Not sure what that's about. But then we get here where she's posting this. Who is BryanFreeman.com? Then she posted this. Horror story. Celebrity lawyer Bryan Freedman is paid $120 to settle rape lawsuit. She just posted this yesterday. This story is so old. This is when Bryan, I mean, I've covered this before, but this was long, like 30 plus years ago, something now at this point. And we can get into it, but when you look at the people who Blake Lively, that's what I was doing, a comparison between Bryan Freedman, the one guy who spends the rest of his life doing right by people, and especially people who've been wrongfully accused of something, which tells me something I need to know about maybe what happened to him, maybe not, but like it happened so long ago and he's been spending the rest of his life, I think, trying to correct it in some way by fighting for the underdog, compared to the people that Blake Lively has on her side, including the B613 Shapiro dude, who was, in my opinion, he's the worst, what he's done when working for Airbnb. However, she posted that horror story. Then she posted this. Lots of similarities in this wild case where a poor girl has been accused of being abused and not being public about it. Bryan sure had a style. Brute force, which I'm sure he used back when. Oh, here's a website. I didn't make it, but I wish I had. Okay. Then we have here, and this was after he what? And then it's like supported Vin Diesel. Then she's just going off. The Baldoni legal team, Bryan Freedman, who is one of the last 6 lawyers against me. We just read that. I mean, anyway, she's just, she's going on a full blitz right now against Bryan Freedman. And here's why. It's kind of messy, but I'm going to get into it. I'm going to try to break it down as best as I can because, again, it's all accusations. It's he said, she said, she shall, she shore by the seashore. Guys, I'm trying so hard, okay? But it's all he said, she said, and it's all about them, the Warner Brothers company, deciding to not renew Ruby Rose for a second contract on the Batwoman show back in 2020. Basically, all you need to know is there's these 2 players. Ruby Rose is at the top, and then you have Douglas Scott, I think his name is. Douglas Scott, that is his name. They both played in Batwoman that was done with CW, Warner Brothers, etc., etc. This was actually filmed in Vancouver. And they had Ruby Rose play Batwoman for one season and then decided not to renew her contract. In 2020, Ruby Rose announced that she would not be returning to play Kate Kane as Batwoman, even though she did the first season. And then in 2021, a year later, in October of 2021, Ruby Rose went on to make a bunch of public allegations on social media as well as in the media. Just a bunch of public allegations against Warner Brothers, CW, that guy, Gray Scott, and a bunch of stuff saying that there was unsafe work conditions with serious injuries. She said that she suffered 2 herniated discs in her back and had to go through emergency surgery. And then the studio forced her back to work 10 days after their surgery. And if she wouldn't return back to work, she claims that the studio would fire the entire cast and crew and everyone would be out of work and they were going to cancel the show if she didn't go back. So she went back to work 10 days after her surgery. She also alleged other injuries on set. She said that there was a stunt double that got hurt directly because of Gray Scott. She said that she was paralyzed, or they were paralyzed. I don't know if it was a guy or a girl. As well as stunt doubles were injured, as well as there was suffering of 3rd-degree burns in some areas, and that Ruby Rose herself almost lost her eye during one of the stunts, I guess. She said that there was unsafe protocols and COVID concerns. Sound familiar? That the production refused to shut down during COVID when they should have. And that is kind of crazy because being here and being in filming, they were very strict about COVID protocols, and I know this for sure, okay? Like in 2020, the COVID protocols were very strict here. Like nobody worked in Canada for almost 2 years, okay? Toronto, everything in Ontario for sure was shut down for almost 2 years. So anyway, she alleges that. Then she also alleged publicly, okay? This is not in a law case. This is not in any kind of claim or anything. This was just public allegations a year after she decided to not return to the show. She said that there was alleged pressure and retaliation of being forced to sign her rights away, that the studio claimed that if she was going to go back to the show, that she wouldn't be able to make any like claims about the working conditions, that she was going to have to sign away her rights as a condition of staying on the show, which sounds a little bit strange. And like, who would even do that? Like, that is so weird. I mean, obviously you're not going to stay on a show if you don't have any rights to your safety and protection. She also claimed publicly that there was behavior of people on set like Gray Scott, who we're going to get into, but just to sum it up, she said that he was very abusive. He was yelling at women. She's called him a bitch. Lack of professionalism. We're going to get into that. She also alleged inappropriate behavior by Warner Brothers, Peter Roth, including hiring a private investigator to follow her around, and just like really inappropriate behavior by Peter Roth. And then she, last but not least, she also alleged mischaracterization on her exit. She claims that she did not quit. She says the studios, Warner Brothers, CW didn't pick up her contract for season 2, so effectively she was fired. Potatoes, potatoes. You didn't return. And this is why it's a little bit he said, she said, because nothing actually got filed as a complaint. There's no legal documents that I can find. There's no public lawsuit. There's no court filing. This was just all from her making these public statements online a year later. But Warner Brothers, NCWs, and the producers came back and they released multiple statements. First of all, the actor that she said was abusive and toxic and screaming at women and claimed to be a little bitch. He said unequivocally, like, none of that happened. He completely says, like, that's not at all what happened. And he's never had a complaint against him. However, the Warner Brothers TV, they released statements and said that they didn't return her back to the show for season 2 because of multiple complaints from cast and crew about her on-set behavior. And each one of them was extensively reviewed and handled privately with her. So, yeah, but who knows? But she's saying that it's all of them. They're saying it's her, and they handled each and every one of the complaints. When asked if Rose quit or was fired, the Warner Brothers said that they did not renew or exercise option for her for season 2, citing all of those complaints that were against her, not because of the unsafe working condition claims that she is now claiming. With respect to the injuries and unsafe conditions, Warner Brothers and CW say that they cooperated with safety investigations with WorkSafe BC in Canada, where filming was, and they disputed certain claims as revisionist history. And Dougray Scott, the actor Rose accused, he just says, like, no, this is all fake and it's completely made up. Now, a lot of things can be true at the same time. Everyone's experience may be clashed a little bit, but without court filings or any kind of union arbitration or any paperwork or anything, it's literally at this point complete he said, she said. When Ruby Rose first came out with all of these allegations, Warner Brothers defended Dougray Scott following the allegations from Ruby Rose. And guess who one of the lawyers was? Bryan Freedman. So the Warner Brothers has backed the Batman actor Dougray Scott after further allegations from co-star Ruby Rose. The studio have called Scott, who plays Batwoman's father, a consummate professional, and reiterated that Rose was fired from the show following multiple complaints about her workplace behavior. I say her, but it says workplace behavior. Warner Brothers also said that Scott had never received any allegations against him of bullying or of abusive behavior on his part. They go on to say Mr. Scott was greatly respected and admired by his colleagues and was a leader on set. Now, what's interesting is when she went public to her social media, I don't know why everyone has to turn to social media to blast, like, don't y'all, business is business. Like, anyway, this is the past, so it is what it is. She wrote, Dougray, I have too many witnesses coming forward with worse than just your anger issues. But you're suing me for $10 million because Greg Berlanti shared his lawyer with you? Please come first so I can use the money from that case to take on Berlanti. This is where it gets interesting. Even though Ruby Rose wrote in that post that he was suing her for $10 million, there was no lawsuit against her. Nothing's ever been filed. It does not appear that it was ever done or that he had done so. But he did issue a statement saying, I absolutely and completely refute the defamatory and damaging claims made up against me by her. They are entirely made up and they never happened. And you can just see here, I mean, how many posts she's made about it, you know. And now, I mean, this was in 2021 and now it's 2025 and she's going again off the rails about Bryan Freedman. In another article here I found, oh, if it works, give me a break here. Give me 1 second. I know how to fix this. Okay. It says here that Ruby Rose was fired from Batwoman because of multiple complaints about workplace behavior. Rose first slammed the network studio and producer behind the CW superhero drama alleging toxic behavior. The studio says despite the revisionist history that Ruby Rose is now sharing online aimed at the producers, the cast and crew, the network and the studio, the truth is that Warner Brothers Television had decided not to exercise its option to engage Ruby for season 2 of Batwoman based on multiple complaints about workplace behavior that were extensively reviewed and handled privately out of respect for all concerned. Okay, but still Ruby Rose went to her Instagram and the way it's just, I just don't like stuff like that. Like, I don't know. I'm not about it, but she wrote, enough is enough. I'm going to tell the whole world what really happened to me on set. I will come for you so what happened to me never happens to another person again. And so I can finally take back my life and the truth. Shame on you. That was in one of the posts, but there's more. To me, it's just like kind of strange because there's unions and there's union reps and there's agents and there's managers and there's entertainment lawyers and you have lawyers. So if I go to use those people. Like if this happened to Ruby Rose, if they threatened her after back surgery, like this, we're going to fire everyone. The show's going to be canceled because of you. You have to come back and force her to come back. There's just in my opinion and professional opinion of working on sets, this is a very rare thing to have happened. That's all I'm going to say, because again, especially someone of her stature. She has handlers, right? And so it just like that just doesn't make sense. Then she said here that Dugray hurt a female stunt double. He yelled like a little bitch at women and was a nightmare. He left when he wanted and arrived when he wanted. He abused women, and in turn, as a lead of a show, I sent an email asking for a no yelling policy, which they declined. Then she goes on to say, I wouldn't return for any amount of money, nor if a gun were to my head. Nor did I quit. I did not quit. They ruined Kate Kane and they destroyed Batwoman, not me. I followed orders, and if I wanted to stay, I was going to have to sign my rights away. Any threats, any bullying tactics, or blackmail will not make me stand down. So anyway, we kind of get the little basis of the story here, back and forth and back and forth. However, Bryan Freedman does represent Berlanti, who she did say. I did research it, and he does represent them. So that is probably why there is now this website dedicated to who is the real Bryan Freedman. What I find very interesting is if the metadata, and I'm sure a lot of people are going to look into this who are more technologically who are technologically oh my gosh, I can't believe that just happened to me. Okay. I'm sure there are people who are more technologically more advanced than I am who are going to be looking into the metadata. I already did some research, and some people are saying this was created in April of 2024. This is very strange to me because who makes websites? Melissa Nathan and Jen Wallace, okay? I mean, they are kind of known for it at this time. However, I don't know what's going on with this thing, but this is very, very weird. Again, and why is it being brought up right now? Why is Ruby Rose right now, 5 years later, bringing up this website about Bryan Freedman? And it's absolutely despicable. Anyway, he who is out sin, please cast the first stone, okay? But Bryan Freedman wants to bury his past and hide his personal transgressions. It is hypocritical that he acts so self-righteous. This is the real Bryan Freedman. Y'all can go check it out if you want to, but I think it's a bunch of baloney and BS. And I think this is yet again part of the entire tactic to smear Bryan Freedman, to silence him against Blake Lively and Ryan Reynolds, and to further attack him and the Wayfarer parties even some more. And now some of the other cast members did come out and have something to say when Ruby Rose started publicly on social media putting all this stuff out there. Bridget Regan, who has currently deleted her Twitter, but before deleting it, tweeted on her account, I'd just like to say I love working at CW Batwoman. I feel very safe on set, and everyone in front and behind the camera are incredibly kind, thoughtful, and supportive. Another person named Cameron Johnson wrote, since it was claimed she walked away last year, I'm sure some of you may be pretty confused or upset, and even more so that a lot of lies were spread today. Just know we have a lot of great souls working on this show, and none of this changes that from the top to the bottom. So I don't know what's going on there, but it's kind of strange that 5 years later now, she is attacking Bryan Freedman today and going off and having a huge crash out. It seems a little bit strange and timed, if you ask me. She currently doesn't have anything in development, and there are no upcoming projects coming out for Ruby Rose, so maybe she's trying to jump on the Ryan Reynolds train. I don't know. I don't know what's going on. Maybe she truly just does have a deep personal vendetta for only Bryan Freedman, but she even said he's one of 6 lawyers. So anyway, it's just strange, but yeah, she's been going hard on this Bryan Freedman all day, and like this website I think is so crazy, and again, hypocritical, because it's like, aren't you guys fighting against the same things? Like, anyway, that's what it is. It's crazy. There's a lot of things that happen, I think, behind the scenes that we just don't know about. Like, I didn't know about all that stuff with Rebel Wilson. I didn't know about all that stuff with on the Horizon set. I didn't know about all of the stuff with Vin Diesel. And now there's this on the Catwoman set. It's like, God, what is going on? Anyway, let's get into it. Court filings. Yep. Wayfarer has spoken. Let's just start here right now with what are we looking at? What is this thing? Sorry, guys. I'm losing my mind. Okay, I'm so sorry. This is the motion to seal. So they have put in depositions from 3 parties. They're all under seal. And what they're doing here is just giving Blake Lively the option of whether or not to continue sealing or not, which I thought was very interesting and good of them. However, Blake Lively might come now and be like, oh, they're bullying, they're making it look like it's my option. Remember what she did like with her deposition and stuff. But this is just saying the redacted portions of the opposition memorandum similarly refer to the testimony contained in the transcripts that Lively designated as confidential. So Ms. Lively said that these were confidential. The Wayfarer parties respectfully request that the court not rule on this letter motion to seal for 1 week so that the parties can meet and confer, and so that Ms. Lively may file a motion for continued sealing if she so chooses. And I hope she doesn't. I want to see these depots, okay? I want to see these depositions. Okay, and then second, we are jumping along to the declaration filed by Eileen Garofalo. She is a brilliant lawyer on the side of Wayfarer, and she's just saying like, yeah, I represent these people, but this is what I found interesting. On September 12th, I deposed third-party Vivian Baker, Blake Lively's makeup artist. That'll be interesting because we remember the makeup artist was apparently in the trailer when Jamie Heath and Justin Baldoni would just barge in all the time, especially the time that she says in detail that Jamie Heath was looking at her in the eyes while she was bumping, and she told him to look against the wall, and he said, I'm sorry, I just usually always look at people when I'm talking to them. Anyway, she was there, and apparently everyone was real traumatized about it. So we'll see if she was left real traumatized about the incident. On September 18th, third party Warren Zavala, Blake Lively's talent agent at WME, was deposed. That will be interesting as to what he has to say. Okay, because was she talking to you? Did she tell you you're her agent? And what exactly did she tell you was happening on the set? That's your first phone call, is your agent. On September 19th, 2025, there's also the third party Danny Greenberg. Danny Greenberg is an agent or former talent agent at WME. Dang, he doesn't work there no more, huh? Can't work for the devil for too long. He is the talent agency, or was for Justin Baldoni. Danny Greenberg was in the complaint, I believe, from the Wayfarer people that said that Ryan Reynolds was going up to WME executives and pressuring them and forcing them to fire Justin Baldoni as a client because he was a sexual predator. So we'll see what Danny has to say about this. I just want to say this was written really well. It's right to the point. They don't kerfuffle, okay? There's no kerfuffling over here. They go right at it, and it's written very well. And basically, they're just telling the judge, if you do rule in Blake Lively's favor, here's all of the things that could go wrong for you, as well as how are you going to rule on something without the actual main case being ruled yet? Because if the main case turns out that Blake Lively was a liar, pants on fire, and none of the charges against the Wayfarer people by a jury happen, then how are they going to work this out? Like, it's premature. But the introduction does say, for the second time, plaintiff Blake Lively seeks draconian relief under a new California statute, California Civil Code 47.1, which creates a qualified privilege for any person claiming sexual harassment under defined California statutes, including FEHA, California Government Code. Section 47.1 authorizes an award of reasonable attorney fees, treble damages, and punitive damages for a failed defamation claim against a party asserting sexual harassment claims without malice and without a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. Thus, whether the privilege and remedies afforded by Section 47.1 apply turn not out on the Wayfarer party's underlying conduct, but on Lively's motive and intent. Whether Lively asserted the claims without malice and with a reasonable basis, factual issues that remain to be tried in the main case. So they're basically saying, like, she's a liar, liar, pants on fire, and we're still trying to prove our side of things and what her motive and intent was, and if they actually did think that there was sexual harassment happening, or if she did it with malice. But they can't come out and just be like, yo, we think Blake Lively's a lying, malicious, crazy ass bitch, which is what some of us would probably like to say. So they're just saying, like, whoa, 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 without going through it and being proven. You still don't know. We still haven't proven her underlying conduct. We still haven't proven her motive and intent, right? So, hello, it was very malicious, and she did it because she was bitter. Anyway, factual issues that remain to be tried at case. As explained in Section 2 below, Sections 47.1's express language raises multiple constitutional concerns which have not been addressed by any California or other court, including its curtailment of free speech and a litigant's right to petition guaranteed by the First Amendment, as well as potential violations of the Fourth Amendment's prohibition against excessive penalties, treble, and punitive. Further, Lively does not explain why California's presumption extortional jurisdiction does not apply to Section 47.1 when Lively is not a California resident and the alleged harassment, which is the basis for her claims, occurred in New York. And on the New Jersey set of the film, it ends with us. Exactly. Anyway, I thought the footnote was kind of interesting here because if you look, it's all like bolded out, but they're giving us a little something because between the minutes of 14421 and 14618, Danny Greenberg testified something. He said something. And I bet that something that he said had to do with Blake Lively being a liar, liar. Okay? A liar, liar, pants on fire. Or Ryan Reynolds or something that they knew that this was false. Or they were just doing it for revenge because let's clock that footnote. I want to see these depositions. Lively, the statute and its legislative history are also silent on whether these remedies are available for dismissal of a consolidated complaint, where the issue of liability and punitive damages have not yet been determined by the theory of fact. The extreme remedies created by Section 47.1 require factual findings that Lively asserted her claims without malice and with a reasonable basis. This inquiry turns on Lively's motives, to wit, whether her complaints of sexual harassment were made with malice and with a reasonable basis, factual determinations within the province of a jury or the court on summary adjudication based on admissible evidence. No theory of fact has made these factual determinations, which are central to the Wayfarer party's defense and will be ultimately determined in the still pending main action. They want a jury, y'all. They are ready to prove that, yeah, Blake. Oh boy. But the way they wrote it, I thought was very spicy, okay? Although Lively contends that to be effective, the remedy should be imposed at an early stage of the litigation, neither the statutory language nor its legislative history address the dismissal of a consolidated complaint before the complaint's sexual harassment claims are tried in the main action. Lively nevertheless contends that Section 47.1's remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishment protracted legal process. Here, however, neither the dismissal of the Wayfarer party's defamation claim nor an award of penalties under Section 47.1 would achieve this statutory goal of preventing ongoing protracted litigation over the same factual issues which determine the applicability of Section 47.1, to wit, whether Lively's claims are valid. Then they do put in the footnote also that the Wayfarer party's claims were initially filed as a separate action, but have now been consolidated with the Lively complaint. That's important. No California court has provided guidance on this issue, including whether a court's determination before trial in the context of Section 47.1 of the complaint's motive and intent would divest a defendant of his right to a defense or trial, or by summary adjudication based on admissible evidence. The application of Section 47.1 to the dismissal of a consolidated complaint while the main action is still pending also raises the specter of inconsistent outcomes. For instance, if the court applies Section 47.1's privilege and remedies at this early juncture, what happens if a jury later finds her claims lack merit? Nor has any California court explained how punitive or treble damages can be calculated without a baseline finding of actual compensatory damages by the tier of fact. Lively, in fact, does not directly address the key issues of her motive and intent, but deflects by recycling the full breadth of her allegations of the Wayfarer party's purported misconduct, which are the basis for pending Rule 11 and New York Rule of Professional Conduct 3.6 sanctions motions. Because remember, she also asked for that too. She's been asking for money since it started. Please, judge, please give me something. Give me some money. The bulk of these allegations have no bearing on the discrete factual issues relevant to a Section 47.1 analysis, specifically whether Lively had a reasonable basis for her sexual harassment claim and acted without malice in asserting it. For instance, Lively argues that the court dismissed the Wayfarer's defamation claim against Ryan Reynolds and Leslie Sloan for failure to plead malice, sufficient evidence of a smear campaign, and strong evidence that the Wayfarer party spread negative stories about Lively. Whether the court found that the complaint failed to plead malice sufficient to state a defamation claim against Ryan Reynolds, Leslie Sloan, or the New York Times, or spread negative stories about Lively is irrelevant to Lively's motive and intent in asserting her sexual harassment claims. Right, because all of that has to do with defamation, the smear campaign, etc., etc. So, what's up, B? And the court did not dismiss the Wayfarer party's defamation claim against Lively for failure to plead malice. Rather, the court found that Lively's complaint, the only basis for the defamation claim asserted in the cross-complaint, was privileged under California's litigation and fair report privileges, and thus it was unnecessary to reach the issue of malice. Notwithstanding Lively's exhaustive rehashing of the full breadth of her allegations, the motion before the court remains short on the relevant factual issues and devoid of legal authority that might allow the court to award the punitive remedies provided in Section 47.1 at this stage of litigation. Lively's motion should be denied because, among other things, Lively fails to show that Section 47.1 or California Civil Code have extraterritorial application. Lively fails to present new facts or law that might warrant reconsideration of the court's previous denial of relief under Section 47.1. No theory or fact has been found based on admissible evidence that Lively's sexual harassment claims were asserted without malice and with a reasonable basis. Thank you. Lively fails to show, and no theory of fact has found clear and convincing evidence the malice required for punitive damages as required by Section 3294. And last but not least, plaintiff has not proven, and no theory of fact has found the actual compensatory damages required as a basis to calculate treble or punitive damages. Plaintiff's motion should be denied. No California or other court has addressed the constitutional concerns and conflicts apparent from the face of Section 47.1. Then they go on here about the 47.1. Lively seeks remedies under California Civil Code 47.1, which provides for severe penalties for unsuccessfully filing retaliatory defamation actions against sexual harassment and retaliation complainants. According to plaintiff, the recently enacted Section 47.1 was intended to deter frivolous claims that force survivors to defend against long and expensive retaliatory defamation lawsuits by imposing significant remedies for success defendants in defamation claims, and was intended to protect victims from the litigation itself. As a preliminary matter, Lively does nothing to address the constitutional concerns and conflicts raised by Section 47.1's express language. First, Section 47.1 conflicts with the right to free speech and petition guaranteed by the First Amendment to the United States Constitution. Well, we already know that Blake Lively isn't really a fan of free speech, so of course she didn't put that in there. I mean, she doesn't like us having free speech, that's for sure. Then they go on to say that the actual 47.1 goes against another law, the Noer-Pennington Doctrine, by imposing a statutory penalty on plaintiffs for unsuccessfully bringing certain types of lawsuits, even when they do so in good faith. So they're saying Wayfarer brought in their lawsuits on good faith, okay? It wasn't just like a retaliatory thing because she spoke up. It was in good faith, okay? So what? People aren't allowed to fight back even when things are proven that it's a lie, right? Second, plaintiffs fail to address how Section 47.1 can be reconciled with California Code, which, consistent with the right to petition, creates an absolute to bar to any defamation claim based on statements made in connection with a judicial proceeding. Specifically, Section 47B applies to any communication made in judicial or quasi-judicial proceedings by litigants or other participants authorized by law. 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. The privilege is absolute and applies to all publications, irrespective of their maliciousness. It protects to publications made outside the courtroom and all torts except malicious prosecution. Because, she's trying to say Bryan Freedman talking to the press. It is desirable to create an absolute privilege, not because we desire to protect the shady practitioner, but because we do not want the honest one to have to be concerned with subsequent derivative actions. Third, plaintiff fails to explain how Section 47.1 should or can be applied when, as here, a defamation claim is dismissed at the pleading stage before the dispositive factual issues of whether plaintiff's claims were asserted with malice and without a reasonable basis, issues of fact within the province of the jury. So they're trying to say, and there's another time where they bring this up too, that it was dismissed before it even got to a point where they were able to prove their case. So that's not okay. Like, how are you going to prove that they did this without, or they did this with malice and it was based not with that, and it wasn't in good faith, et cetera, et cetera, et cetera, when it was already dismissed ahead of time. Like, they weren't even able to prove anything. Then, in the same vein, Section 47.1's approach to punitive damages under California Code 3294 is particularly troubling. As explained in Section 2E below, California has a long-standing rule that there is no right to punitive damages. Rather, punitive damages require clear and convincing evidence of malice, a determination left to the discretion of the tier of fact based on admissible evidence. They go on to question, again, a lot of the things happening in 47.1 because it is so new and it hasn't been used before. And I think it should be questioned also, especially in cases like this where litigation is still going on, where it seems very clear that the plaintiff has lied about some things. It may have been for some or all of these reasons that the court has already declined to award Lively the relief she seeks under Section 47.1, albeit without prejudice. Because he did do it without prejudice. But that's funny. Albeit without prejudice. In so doing, the court explicitly noted that it had not ruled on whether Lively's statements were privileged under California Code 47.1, and that if Lively chose to renew her motion, she should fully brief the impact of this opinion, if any, as well as the issues raised in prior briefing. While Lively now resuscitates her motion with an extensive exposition of the facts asserted in prior pleadings and the order, She does not cite new facts or law relevant to whether she had a reasonable basis for her sexual harassment claims and whether her claims were asserted with malicious intent. Simply put, nothing has changed since the order, and Lively and this renewed motion appears to be nothing more than an improper request for reconsideration, seemingly contrived as a thinly veiled effort to poison public perception and the potential jury pool. At best, the motion is premature. The court should decline Lively's invitation to interpret Section 47.1 as an issue of first impression in the dearth of any guidance from a California court and impose heavy-handed penalties, which would require the court to make premature factual determinations. Then they go into the plaintiff fails to show that Section 47.1 or Civil Code 3294 may be applied extraterritorially. Because all of the conduct happened in New York and New Jersey, this is a California statute, so it would have to be extraterritorially in order to have it applied here. And FIHA should not be construed to apply to non-residents employed outside the state and when the tortious conduct did not occur in California. Then they say, although proposed amici curiae offered in support of Lively's position, quote, extensively from Section 47.1's legislative history, in fact, Section 47.1 does not include any affirmative indication that it was intended to apply to conduct outside of California. It does go on to explain that just because they're residents of California, it doesn't mean anything, like, et cetera, et cetera. Then it goes, neither Lively's complaint nor the motion state facts sufficient to establish a substantial connection between the Wayfarer defendant's unsuccessful defamation complaint filed in and dismissed by a New York court or the underlying sexual harassment claim, which would give rise to the privilege she seeks to invoke. Lively is a New York resident. The core conduct alleged sexual harassment on the It Ends With Us set and the filing and the dismissal of the Wayfarer party's unsuccessful defamation claim, the basis for Lively's request for remedies under Section 47.1 did not incur in California, but that is blacked out, but obviously we know it's New York, New Jersey. While Wayfarer is headquartered in Los Angeles, the employee or employer's residency is not sufficient to overcome the presumption when the tortious conduct is outside of California. Section 47.1 cannot apply where, as here, there are no factual findings that Lively's claims were asserted without malice and with a reasonable basis. Section 47.1 creates a privilege log for communications made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged, so long as the speaker has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. The Wayfarer defendant's defamation claim was dismissed pursuant to Rule 12b-6 for failure to state a claim. The order dismissing the claim expressly states that the court did not consider whether the Wayfarer parties pleaded malice, but dismissed the claim based on privileged grounds. Plaintiff's harassment claims remain pending, and the merit of those claims, as well as Lively's motive and intent in asserting them, will ultimately be decided by a tier of fact. Like a jury, bitch! Indeed, a centerpiece of the Wayfarer party's defense is that Lively's claims have no merit and were asserted for an improper purpose. The jury must resolve the threshold question of the defendant's knowledge of facts on which his or her claim is based. Plaintiff does not explain how the court might eliminate the risk of inconsistent findings on the pivotal issue in this case. Lively's harassment claims, should this court prematurely decide that Lively's sexual harassment claims were asserted without malice and with a reasonable basis, nor does plaintiff provide any authority for the notion that the Wayfarer defendants can be stripped of their rights to a defense at this early juncture in the context of a Section 47.1 motion. Thank you. That's such a good paragraph. Lively similarly fails to identify new facts that might support her motion. The bulk of the allegations have no relevance whatsoever to this motion, which is not about the Wayfarer's motives or conduct, but about Lively's motive and intent. In fact, Lively's motion is laden with extraneous and irrelevant facts. For instance, Lively argues that Wayfarer's defamation claims against Ryan Reynolds and Leslie Sloan were dismissed for failure to plead malice. Lively ignores that even assuming a pleading defect can be the basis for Section 47.1 remedies, the court did not base the dismissal of the Wayfarer party's defamation claim against Lively on this ground, but rather on the ground that it was subject to California's litigation privilege and the fair report privilege, which we already went over. So, I knew they were going to bring that up because, hello, the judge had it right in his ruling right there. That's why I was like, did Lively even read her own ruling? What's going on? This, her lawyers, they have a client issue. I'm going to tell you right now, I think they have a massive client issue. While a plaintiff who proves his case is always entitled to actual damages, a plaintiff is never entitled to punitive damages as a matter of right, not even upon the clearest proof of malice in fact. A plaintiff must prove by clear and convincing evidence that the defendant acted with malice, oppression, or fraud in bringing their defamation cross complaint. Conduct which is intended by the defendant to cause injury to the plaintiff, or despicable conduct which is carried on by the defendant with a willful and conscious disregard of the rights or safety to other. Despicable conduct is conduct that is so vile, base, contemptible, miserable, wretched, or loathsome that it would be looked down upon and despised by most ordinary, decent people. In the defamation context, to show actual malice, plaintiffs must demonstrate a defendant either knew his statement was false or subjectively entertained serious doubt his statement was truthful. The burden of proof by clear and convincing evidence requires a finding of high probability. The evidence must be so clear as to leave no substantial doubt. It must be sufficiently strong to command the unhesitating assent of every reasonable mind. Whether a defendant acted with malice is an issue of fact for the jury, and it is within the exclusive province of the jury to say whether or not punitive damages shall be awarded, and the granting or withholding of punitive damages may not legally be influenced by any direction of the court. Although on this record, I thought this was a little bit of a poke, a gotcha, a little to the judge, Although on this record, the opposing of punitive damages would have been permissible, it was the jury's exclusive prerogative, after being duly instructed to find defendant acted without malice and therefore declined to award punitive damages. It would have been up to the jury, but it was already dismissed before they can prove any single thing about it. Plaintiff simply ignores the requirements that malice may be proven with clear and convincing evidence, and finding of malice and punitive damages is within the exclusive province of the jury, and the court is prohibited from influencing the jury's decision on whether to award punitive damages. Instead, plaintiff avers that as for punitive damages, the record as it currently exists is sufficient for the court to determine the Wayfarer parties engaged in oppression, fraud, or malice by bringing or maintaining their claims against Miss Lively. This argument, while facile, is contrary to the law. Punitive damages typically require a finding of actual compensatory damages. Put another way, what exactly would the court be trebling? Thank you. So in that, they're basically saying that if the judge were to rule on this, which is very, very slim, they're saying by him ruling on it, he's pretty much already made the minds up to the jury. And I don't think Judge Lyman is going to do this. I think Blake Lively getting this motion granted is such a small percentage. It doesn't make any sense. It's very premature. Nothing in her case has been proven yet. It's still ongoing. So we'll see, but they had to respond, of course, because Blake Lively's been asking. I mean, this is now the second time that she's asked for attorney fees. So we'll see what happens there. But that was their response, and that's everything I have for you guys. Let me know what you think. Let me know what you think is going to happen. And no hate to Ruby Rose, y'all. I was just trying to explain to you guys what happened with Warner Brothers and Bryan Freedman and all of that. I actually loved Ruby Rose. I thought she was a great actress. I'm not really sure why she stopped working in 2020. I guess, she's been slamming some networks and stuff. So I don't know what's going to happen there, but I don't like her attacking my boy, Bryan Freeman. Okay. I know that he has a past. He has one incident that happened in college, and you don't know how that ended or how it was resolved or anything. I don't know. Anyway, I'm on the side of Wayfarer until proven otherwise. Okay. So that's me. That's in my heart. I stand for truth, justice, and I really think that Wayfarer here is innocent, and I'm going to keep riding for them until, again, I am proven otherwise. Where's the evidence? Where's any proof? Where's nothing? But I want to see those depositions. I'm telling you right now, I want to see those depositions. So I hope they come unsealed for sure. But until then, I will see you tomorrow. Thank you so much. I hope you're having the best day. I am now going to go and Buckley's my face off. Okay, so love you so much. I'll talk to you soon. Bye.